In the last video, I covered what a not-for-profit organisation is and what it isn't, and we looked at some of the questions to think about before starting up, such as where your income will come from, who will be involved in running the group, and whether you should incorporate your organisation. So now I'm going to run through the most common legal structures of not-for-profit organisations. As we go through the list, keep in mind these two things. The points we covered in the last video about voting members, incorporated versus unincorporated, and how your organisation will be funded. And that none of the terms not-for-profit, charity or social enterprise are actually legal structures in themselves. So in order to set one up, you'll need to choose from one of the following. An unincorporated association. So for community groups run by volunteers doing something to benefit either themselves or their local community, with no plans to employ staff or lease premises, an unincorporated association is the simplest and often the best place to start. The volunteers who set up the group become the voting members. It can be a charitable group, but it doesn't have to be, and I'll talk a little bit more about this in the next video. If it is a charitable group, once its income exceeds £5,000 per year, it would need to be registered with the Charity Commission. Other than that, you don't need to register the group when you set it up. All you would need is a simple constitution that sets out the main objectives of the group. Therefore, as the name suggests, this is an unincorporated type of not-for-profit. A charitable trust. A charitable trust is a type of charity that's run by a small group of people known as trustees. The trustees are appointed rather than elected, so it doesn't have voting members. A charitable trust is not incorporated, so it can't enter into contracts or own property in its own right. To set up a charitable trust, you would need to write a trust deed, declaring that the group's objective is legally charitable. More about this in the next video. And again, it must be registered with the Charity Commission if and when the annual income exceeds £5,000. A charitable incorporated organisation. A charitable incorporated organisation, known as a CIO, is a type of charity which is incorporated. And this is quite a new legal structure. In fact, it was only introduced in 2013. There are two types of CIO. The association model is a membership organisation which has voting members. The foundation model is run by a small group of appointed trustees and therefore does not have voting members. CIOs must be registered with and report to the Charity Commission regardless of their income. And they must use a model constitution approved by the Charity Commission. A company limited by guarantee. A company limited by guarantee is a company which does not distribute its income to shareholders. It means it can be not-for-profit if all surplus income is reinvested back into the organisation. A company limited by guarantee is incorporated and has voting members. It's controlled by a group of directors who can be either paid or unpaid. Companies limited by guarantee are registered with and regulated by Companies House. To establish a company limited by guarantee, you must adopt a governing document called a memorandum and also have articles of association, and you must submit these two documents to Companies House. There are two main types of company limited by guarantee that you can register. A charitable company. A company can be a charity if it meets the legal requirements required by charity law. This must be clear from the governing document. So if you wish to set up a charitable company, you should use the model memorandum and articles of association approved by the Charity Commission. In order to be considered charitable, the directors of a charitable company are usually unpaid. Establishing a charitable company involves registering with the Charity Commission as well as with Companies House, and then submitting your annual report and accounts to both of these organisations. A community interest company. A non-charitable company can still be a not-for-profit organisation, often referred to as a social enterprise. More on this in a later video. If your organisation is not charitable, you can guarantee your not-for-profit status by becoming a community interest company, also known as a CIC or KIC. CICs commit their assets and profits permanently to the community by means of an asset lock, ensuring that all assets are used for the benefit of the community. However, CICs can have paid directors. To register a new CIC, you'd need to apply to Companies House, and you'll need to include with your application a CIC 36 form, which is where you describe how your company will benefit the community. Applications are assessed on this basis by the CIC regulator. Community Benefit Society. A community benefit society is owned by its members. They hold shares and they vote within this democratic structure. The society must exist primarily for the benefit of the wider community. Profits must also be used to benefit that community. If it wants to have not-for-profit status, a community benefit society must apply for a statutory asset lock similar to a CIC. It can register as charitable with the Financial Conduct Authority if it has aims that are exclusively charitable and it has a statutory asset lock, specifying that any assets would be transferred to another charity if that organisation wound up. This allows a community benefit society to call itself a charity, even when it's not regulated by the Charity Commission. A community benefit society is a useful structure if your community wishes to take control of an asset, such as a building. You could fund your organisation by selling community shares and run the service to benefit the wider community. A community benefit society is incorporated and it can have paid directors. A cooperative society. A cooperative society is a similar structure to a community benefit society, but its main purpose is to provide services to its members rather than to the wider community. Cooperative societies must be based on the cooperative values of self-help, self-responsibility, democracy, equality, equity and solidarity. In general, membership to a cooperative society is open to people who use the services by the society or work for that society, and the profits can be distributed to those members, providing that this is not the primary purpose of the organisation. A cooperative society is not seen as charitable because its beneficiaries are its own members rather than the public or wider community. A cooperative society is incorporated, it has voting members and it can have paid directors. So there we have it, 7 types of legal structures for not-for-profit organisations that you can choose from.